All right, so let's start the session. Hello and welcome to Unacademy. My name is Aditi Bhatt and I'll be conducting your session on daily legal current affairs, and we will be analyzing today's the Hindu newspaper. Uh, so before I proceed further, you can use this link to join the Telegram channel wherein I'm providing regular updates with respect to classes. I'm also sharing the Hindu newspaper PDF for reference of all the students who do not have subscription to the Hindu newspaper. And I'm also sharing relevant notes on topics and concepts that are important from exam point of view, right? So also, if you're planning to take any of the subscriptions on an academy platform, then to unlock free classes and discounts, you can use the referral code ABCLAT. All right. So let's see the today's highlights. So today in the newspaper there were two very important cases. So we will be discussing those, and right, there were two very important. So first news item. There were actually multiple news articles related to these two issues. So first issue that we will be dealing with is Sena versus Sena dispute. That is the Shiv Sena case, and who is the real Shiv Sena, and what are the Supreme Court's observation. Right? Yesterday, Supreme Court has given a decision, and so we'll see what has been the ruling given by Supreme Court. Another issue that we will be looking at is the Delhi Chief Minister versus Lieutenant Governor of Delhi, the powers related to them, and the case that is going on, and what has been the ruling given by the Supreme Court, right? So, let's see. This is the governor's decision to call floor test strong. This is what Supreme Court has stated. Now, these news articles, right, related to this particular issue, can be viewed from constitutional law perspective. It is important to understand some very basic concepts related to these this news item, right, related to this particular issue, floor test, and so this is the case that's going on in this that's really the Supreme Court has given decision in the case of Subhash Desai. The name of the case is Subhash Desai versus Principal Secretary, Governor of Maharashtra, and others. This is a 2023 judgment, right? Okay, so let's understand now. There is a chronology before going or before explaining you the concepts. I want you to know the chronology of this particular case in very simple this thing. So in brief, I'll tell you the chronology. What has happened? How or when did this particular thing, the entire dispute, actually start? So you see, before 2019, there was Devendra Fadnavis government, right? The BJP government in Maharashtra, and in 2019 they had the elections, Maharashtra elections, and state elections, and in that, basically, see, in 2019 elections. So I'll start from there. 2019 elections, Maharashtra. So the BJP and Shiv Sena had contested the election together. So there was a pre-poll alliance between BJP, or actually it was right, NDA and Shiv Sena. So just write BJP and Shiv Sena. All right. So there was a pre-poll alliance. A pre-poll alliance is that is before the election is conducted. So the alliance formed by parties before the election takes place is a pre-poll alliance, and a post-poll alliance is the one that takes place after the election results have been declared. So that is a post-poll alliance, right? So BJP and Shiv Sena had a pre-poll alliance, right? And then they conducted, they basically went through the elections together. And of course, the citizens of Maharashtra, the residents, basically all the people of Maharashtra, for they voted for this particular alliance. Basically, the vote was given for this alliance, right? And once the election results were announced, so we need to understand the number of legislative seats. So the total number of state legislative assembly seats in Maharashtra are 248, sorry, 288, and the majority is 145. So any party, whoever gets more, whoever secures 145 or more than 145 seats, that party will automatically uh, become the government in Maharashtra. Okay, that will basically hold the government in Maharashtra. So what happened? The election results. What were the election results in 2019? BJP secured BJP secured 105 seats. Shiv Sena secured 56 seats. So if we see 105 plus 56, it basically it is showing that it is clearly showing that the pre-poll alliance of BJP and Shiv Sena has won, right? And the NCP, who was NCP, National. Okay, NCP is the basically NCP secured 54 seats, and INC, they had their alliance, INC and NCP, INC secured 44 seats in the elections, in the 2019 elections, right? So the legislative, so clearly BJP and Shiv Sena alliance was winning the election, and was to resume the government. But what happened was there was some dispute, like Shiv Sena wanted. So there was earlier it was decided that Devendra Fadnavis would then if the alliance won, if the alliance wins the election, then Devendra Fadnavis will become the chief minister. So it was actually decided, pre-decided. But then somehow after the election results came, Shiv Sena changed its stance and said that we want to nominate our candidate to become the chief minister. So there was some dispute, because of which the Shiv Sena basically joined hands with NCP and INC in a post-poll alliance, right? So they formed a post-poll alliance called known as Mahavikas Agadi, right? So this was a post-poll alliance wherein Shiv Sena joined hands with NCP and INC, and then they basically resumed. Right. So this was this thing. What happened in the meanwhile? Meanwhile, when the election results were so, but there was a dispute going on. The governor, seeing that there was no clear government in the state of Maharashtra, in that case, in that situation, the governor had, imposed Article 356 of the Constitution. 356 of the Constitution talks about president's rule. Okay, because there was no clear government, okay, in picture, and there was a president rules, and there was a breakdown of constitutional machinery. There was a breakdown of constitutional machinery, right? Since there was no clear government in sight, so Article 356 was imposed, that is president's rule. And under this, when the Mahavikas Agadi was formed, after that, when the MBA was formed, right? When the MBA was formed, and after that, Uddhav Thackeray was he was appointed as chief minister, right? Appointed as chief minister of Maharashtra, right? So in when this happened, when he became the chief minister, he appointed Eknath Shinde as the chief leader of Shiv Sena, right? And he also appointed Mr. Sunil Prabhu as the chief whip, right? So the role of the chief whip is to act as a connect or link between the party, between the party, right, between the party faction and the organization and the people of the organization, the organization members, right? So in this case, organization is the Shiv Sena is the organization, and party faction is the members of the Shiv Sena who have been elected, or who are forming the legislature of the state, right? So who are part of the political this thing, right? So this is what the role of the chief whip is, to act as a link between the party and the organization, right? The political faction, that is. So the role of the whip is also to basically disqualify or ask for disqualification. What happens is the disqualification generally, okay, we need to understand first of all the anti-defection law. Okay, so the anti-defection law was it is incorporated in the 10th schedule of the Constitution of India, right? This was inserted by the 52nd Constitutional Amendment Act of 1985, right? And the defection law says that if there is a violation of a whip, hmm, then it leads to disqualification from the party, from the political faction, right? Disqualification of right, of the members. Now uh, so the role of the chief whip का क्या रोल होता है? जो chief whip होता है उसका रोल होता है to issue whips, and in case some member, if the members are violating any of the whips, then to then inform. Basically there are three types of whips. Okay, firstly there is a one line whip. One line whip में basically क्या होता है कि the members are supposed to be the members, it is not mandatory for the members to be present or voting, right? So this is so it is not mandatory, right? The second type is the two line whip. Under this, um, it is important for the members to be present, but it is not mandatory for the members to vote, right, on a particular issue. But again, the members cannot present may or may not vote, right, depending on whatever is being discussed in the house of the floor of the house, that is the state legislative assembly. And the third type of whip is a three line whip. Now this whip is a coercive whip. This is a coercive whip, and it is mandatory, which means that the chief whip decides and basically states all the members to be present, to vote, and to vote in a particular way. Vote uh, in a particularly vote, like whether if there is a bill that has been introduced, huh? So the chief whip decides that whether according to the with the consultation of the party and the organization, it is decided that whether the organization is supporting, organization as well as the party or the political faction is supporting the bill or is not supporting the bill. So then the three line whip is issued in case in case the parties or the organization is not supporting the bill, or if it is supporting the bill, that's a bill that is important. So in us case mein the three line whip is issued, and it is coercive and it is mandatory. And if the members violate this whip, if the members do not obey it, the three line whip, then they are disqualified under the anti defection law, right? If there is, if the members do not obey the three line whip, ठीक है? तो ये होता है चीफ whip का काम, right? So what happened was that there was a क्या हुआ, मतलब जून में सी 2019 में जब इलेक्शंस हो गए थे और फिर जब महाविकास अघाड़ी फॉर्म हो गई, एट दैट टाइम उद्धव ठाकरे वाज अपॉइंटेड एज द सीएम and the government went on, but then what happened in June 2022? June 2022 में क्या हुआ, that there was a faction in the political party that is amongst all the amongst the 56 members, जो 56 members जो elect हुए थे, right, members that have been elected in the state legislative assembly, तो वो 50, क्योंकि शिवसेना ने 56 सीट सिक्योर करी थी, राइट, तो 56 मेंबर्स जो शिवसेना के इलेक्ट हुए थे, जो कि स्टेट लेजिस्लेटिव असेंबली में थे, तो उनमें से 15 ने रिबेल कर दिया, सॉरी 16 ने रिबेल कर दिया, यानी कि दे डिसोबेड द थर्ड व्हिप. तो एकनाथ शिंदे along with 15 other MLAs basically disobeyed the whip, three-liner whip, and in that case they also went to different they went to Surat and then Assam, right? But then उसमें क्या हुआ कि जो उस टाइम पे लोग उस टाइम पे स्टेट लेजिस्लेटिव असेंबली का स्पीकर नहीं था, द डेप्यूटी स्पीकर वाज बेसिकली टेकिंग द रोल ऑफ, और the deputy speaker had at that time been was serving as the speaker, right? So at that time the speaker basically called for disqualification of those members and issued notice disqualification and issued notice to 16 MLAs. ठीक है, 16 MLAs को नोटिस भेज दिया गया अबाउट द डिस्क्वालिफिकेशन नोटिस, ठीक है. एंड दिस ऑफ कोर्स द नंबर ग्रेजुअली, द नंबर लेटर इंक्रीज, जो 16 नंबर था वो इंक्रीज हो गया टू 40 MLAs, ठीक है. तो अब मतलब दिस वाज मोर देन 1/3 ऑफ द टोटल नंबर ऑफ मेंबर्स, 1/3 से ज्यादा होगा, मोर देन सॉरी मोर देन 2/3 से ज्यादा, 2/3 से ज्यादा मेंबर्स हो गए, राइट. तो 2/3 प्लस सो और इसमें क्या हुआ, बिकॉज ये जो 16 मेंबर्स थे उनके लिए, उनके बिहाफ, उनके अगेंस्ट नोटिस इशू करी गई बाय द स्पीकर ऑफ द स्टेट लेजिस्लेटिव असेंबली that they have to respond within 48 hours, ठीक है. Then the faction of 16 MLAs, these 16 MLAs went to the Supreme Court stating कि ये जो 48 hours का पीरियड है ये अनरीजनेबल है, ठीक है, unreasonable, right. The Supreme Court then stated that they should be given 14 days time, 14 days time, so that we can comply with principles of natural justice, principles of natural justice का जिसमें कि violation ना हो, right. and उस 14 दिन के टाइम में क्या हुआ, उन 14 days में they sent a letter, they sent a dissatisfaction, a letter basically जो कि उनका dissatisfaction बता रहा था They were dissatisfied with the present government, and then they wrote the letter to the governor. Governor, the governor used this letter as a, or basically considered this letter or deemed the letter to be a no confidence motion, or a lack of confidence, loss of confidence in the majority party. So this was loss of confidence. Okay. So because he deemed that letter to be a loss of confidence, or showing deemed as loss of confidence in the majority party, so then the governor ordered फ्लोर टेस्ट. फ्लोर टेस्ट क्या होता है? बेसिकली जब भी जो मेजोरिटी पार्टी इलेक्ट हुई है, ठीक है, फ्लोर टेस्ट जो द आइडिया ऑफ फ्लोर टेस्ट कैसे आया? सी वी आर अ पार्लियामेंट्री डेमोक्रेसी, ठीक है. पार्लियामेंट्री डेमोक्रेसी होने का क्या मतलब है? दैट द एग्जीक्यूटिव इज ऑलवेज रिस्पॉन्सिबल टू द एग्जीक्यूटिव इज रिस्पॉन्सिबल टू द लेजिस्लेचर, ठीक है, to the legislature, right? So क्या होता है कि the legislature, the executive basically is what? The executive is the council of ministers of the state, right? They constitute the executive. So the council of ministers only are they are only a certain percentage of the entire legislature, right? They constitute only a certain percentage of the entire legislature, right? So 15% of the entire legislature. So that executive has to be responsible. And जब भी कोई floor test governor अगर if the governor calls for any floor test, it means that there has been a no confidence motion passed, ठीक है. नो कॉन्फिडेंस मोशन आया है जिसमें कि जो एग्जीक्यूटिव जो इलेक्टेड मेंबर्स हैं, राइट, इफ द party has lost confidence, if the members, or if the legislature has lost its confidence in the elected members, then voting will be put again. So the floor test is that voting will be conducted again on the floor of the house, ठीक है, on the floor of the house means the state legislative assembly in this case, ठीक है. And if they fail to secure, if the executive fail to secure majority, then they lose government. They lose the government. So this is the whole idea behind floor test. So अगर वो लोग majority secure करते हैं, then they are safe, right? Then they can resume their power, or that is resume their functioning, ठीक है. Or if they lose the majority, if they fail to secure the majority votes in the house, on the floor of the house, in that case they lose the government, ठीक है. तो उसके बाद क्या होता है कि फिर से वापस से इलेक्शंस कंडक्ट किए जाते हैं, और इन द अदर केस द ऑपोजिशन पार्टी में से जो भी उनके बाद वाली जो भी पार्टी जिसके मैक्सिमम वोट्स थे, उसमें से किसी को चूज करके देन गवर्नर कैन अपॉइंट दैट पर्सन एज अ सीएम, ठीक है. सो दिस इज अ होल आइडिया, दिस इज द फ्लोर टेस्ट कॉन्सेप्ट, ठीक है. सो पार्लियामेंट्री डेमोक्रेसी में ये होता है. तो उस टाइम पे क्या हुआ, गवर्नर ने लेटर को डीम करके कि ये लॉस ऑफ कॉन्फिडेंस शो कर रहा है, तो ही कॉल्ड फॉर अ फ्लोर टेस्ट. सो व्हेन ही कॉल्ड फॉर अ फ्लोर टेस्ट, उस टाइम पे क्या हुआ कि जो उद्धव ठाकरे ही वेंट टू सुप्रीम कोर्ट स्टेटिंग दैट फ्लोर टेस्ट के रिजल्ट्स तो सही नहीं आएंगे, बिकॉज 56 में से 40 मेंबर्स हैव एक्चुअली रिबेल्ड, ठीक है. 56 में से 40 तो ऑब्वियसली वोटिंग उसके फेवर में नहीं आएगी. तो उसने कहा ही सॉट स्टे ऑर्डर ऑन फ्लोर टेस्ट, ठीक है. तो उस टाइम पे सुप्रीम कोर्ट ने कहा that the result of the floor test will be judicially reviewed, right? But did not put a stay order. So did not give stay to. So there was no stay order on the फ्लोर टेस्ट. ठीक है, तो गवर्नर ने जो फ्लोर टेस्ट कॉल किया था, गवर्नर had called for the floor test, and then Uddhav Thackeray went to the Supreme Court seeking stay order on floor test, but Supreme Court ने stay order नहीं पास किया. ठीक है, तो what happened was Uddhav Thackeray during that time he voluntarily uh, submitted his resignation even before the floor test was conducted. He voluntarily submitted resignation from the post of Chief Minister even before the floor test was conducted. ठीक है, तो फ्लोर टेस्ट होने के पहले ही resigned and he voluntarily resigned. ठीक है, then what happened, अब floor test भी नहीं हो पाएगा अब तो, because and Uddhav Thackeray has also resigned. So in that case क्या हुआ, because 40 out of 56, 40 people, 40 MLAs out of 56 were inclined with the Eknath Shinde faction. ठीक है, so then Eknath Shinde was appointed as the chief minister, right? Okay. ठीक है, सो ये हुआ 2023 में. 2020 ये तो 2022 में गवर्नमेंट चलती रही एक नाथ शिंदे की. ठीक है, 2023 में इलेक्शन कमीशन ने, क्योंकि सिंबल्स की बात आई थी कि शिवसेना हु इज द रियल शिवसेना, तो सिंबल जो शिवसेना का जो सिंबल है, पॉलिटिकल सिंबल, ठीक है, तो वो कौन किसके पास रहेगा, राइट? सो इलेक्शन कमीशन हैड टू डिसाइड दैट. ठीक है, एंड इलेक्शन कमीशन कौन से, देयर इज अ सिंबल्स ऑर्डर of 1968. ठीक है, that is decided by the on the basis of this it is decided by the election commission. ठीक है, and so the election commission stated that the symbol of bow and arrow will go to whoever has more legislative grounds. तो legislative grounds पे ये decide किया इलेक्शन कमीशन के ऑर्डर ने कि the Eknath Shinde group, the Eknath Shinde group will get the symbol of bow and arrow. ठीक है, and so this case, अभी जो केस चल रहा है, the name of this case is Subhash Desai versus Principal Secretary, Government of Maharashtra and others. ठीक है, now this case is going on because जब ये सुप्रीम कोर्ट में जब एकनाथ शिंदे के जो फैक्शन था, वो लोग जब सुप्रीम कोर्ट गए थे ये 48 आवर्स वाला क्लेम लेके, राइट, डिस्क्वालिफिकेशन, एंड सो 48 आवर्स टाइम पीरियड लेके, दे हैड ऑल्सो एक केस, एक पुराना केस, एक अरुणाचल प्रदेश स्टेट लेजिस्लेटिव असेंबली का केस है. दिस इज अरुणाचल प्रदेश स्टेट लेजिस्लेटिव असेंबली केस. ठीक है, केस का नाम है, this case is basically known as the Nabam Rabia case. Alright, so this Nabam Rabia case, इसमें क्या हुआ था कि जो स्पीकर था, स्पीकर के अगेंस्ट मोशन जारी हुआ था फॉर रिमूवल ऑफ स्पीकर, राइट, फॉर रिमूवल ऑफ स्पीकर. This motion was pending in the house, ठीक है. And हाउस में पेंडिंग था, और स्पीकर न्यू कि कुछ कुछ लोग हैं जो कि दे आर पार्ट ऑफ द स्टेट लेजिस्लेटिव असेंबली, सो दे माइट बिकॉज दे हैव ओनली कॉल्ड फॉर मोशन फॉर द रिमूवल ऑफ स्पीकर, तो वो वोट कर देंगे, ठीक है. तो वो लोग वोट करें, वो अपना मोशन एक्सरसाइज करें उससे पहले, वोट अपने एक्सरसाइज करें उससे पहले ही एक्चुअली रिमूव्ड certain MLAs on grounds of disqualification, ठीक है. सो इस केस में, ये जो केस था, इसमें दिस वाज अ 5 जज बेंच केस. 5 जज बेंच यानी कि इट इज अ कॉन्स्टिट्यूशनल बेंच, ठीक है. कॉन्स्टिट्यूशनल बेंच का एक मैटर था ये. उसमें सुप्रीम कोर्ट ने बोला, सो सुप्रीम कोर्ट इन दिस केस स्टेटेड कि the speaker of the state legislative assembly is prohibited to call for disqualification of members if the motion calling for his removal is pending on the floor of the house. That is, the speaker of state legislative assembly is prohibited to call for, or to call for disqualification of members if the motion calling for his removal is pending on the floor of the house. ठीक है. तो ये केस सुप्रीम कोर्ट ने इस पर्टिकुलर केस में ये डिसीजन दिया था, राइट. एंड दिस वाज द केस दैट वाज साइटेड बाय द or that was basically referred to when the Eknath Shinde faction had approached the Supreme Court, ठीक है. तो अब इस केस पे बात चल रही है that now of course now the Supreme Court, अभी क्या रूलिंग दी है सुप्रीम कोर्ट ने, that Supreme Court has now called for the correctness of the Nabam Rebia judgment, ठीक है. And this will be reviewed. How will this be corrected? This will be reviewed. This particular judgment will be reviewed by a 7 judge bench, ठीक है, because larger bench ही review कर सकती है. Already it was given by a constitutional bench. Now it will be reviewed by a 7 judge bench. And so that what happened in this case does not happen again in future, ठीक है. So right now there were other also कुछ और observations थे जो सुप्रीम कोर्ट ने इस पर्टिकुलर जजमेंट में दिए. इस पर्टिकुलर मींस दिस केस ऑफ सुभाष देसाई वर्सेस प्रिंसिपल सेक्रेटरी, ये जो केस था, इसमें कुछ और ऑब्जर्वेशन सुप्रीम कोर्ट ने दिए. व्हाट वर द अदर ऑब्जर्वेशंस? So सो सुप्रीम कोर्ट स्टेटेड अभी क्या है, बिकॉज एकनाथ शिंदे जब गवर्नमेंट आ गई तो उन्होंने क्या किया कि उन्होंने जो चीफ विप था सुनील प्रभु उसको हटा के दे अपॉइंटेड अनदर चीफ विप. ठीक है. सो अनदर चीफ विप वाज अपॉइंटेड. एंड ऑफ कोर्स क्योंकि नई गवर्नमेंट आ गई थी, तो जब नई स्टेट लेजिस्लेटिव असेंबली में किसी भी स्टेट के अगर नई सरकार आती यानी नई गवर्नमेंट स्टैब्लिश होती है, तो ऑब्वियसली जो स्पीकर और लोकसभा जो सॉरी नॉट लोकसभा, द स्पीकर ऑफ द हाउस एंड द डेप्यूटी स्पीकर भी उसी फैक्शन में से अपॉइंट होते हैं, राइट. दे आर ऑल्सो इलेक्टेड फ्रॉम द सेम फ्लोर ऑफ द हाउस, राइट. So then there was a new speaker of the state legislative assembly was elected. तो जो new speaker था, the new speaker that has been elected is Mr. the so new speaker, जो new speaker as in जो एकनाथ शिंदे गवर्नमेंट का जो स्पीकर है स्टेट लेजिस्लेटिव असेंबली का, दैट इज मिस्टर राहुल नार्वेकर, right. Now he has been dealing with two opposing claims. He has two opposing claims for the post of chief whip. ठीक है. So chief whip, if you remember, it was appointed by the Uddhav Thackeray government, right. Uddhav Thackeray had appointed the chief whip, and now it is being decided who will remain as the chief whip, whether the old chief whip will come into picture, old chief whip, or the new chief whip. ठीक है. सो ये कौन डिसाइड करेगा? ये स्पीकर डिसाइड करेगा. जो स्पीकर है स्टेट लेजिस्लेटिव असेंबली का वो डिसाइड करेगा. इन केस स्पीकर, और डिसाइड कैसे करेगा? ही हैज द ड्यूटी टू इन्वेस्टिगेट एंड इंक्वायर. पूरा मतलब he has to comply with the constitutional provisions, right. Investigate, inquire, basically he has to do his due diligence. Okay. So once he will do his due diligence and the competing claims, so competing claims को settled करने के लिए, then after his due diligence he will appoint whoever will be the appropriate chief whip, right. He will appoint that appropriate person as the chief whip, and after that basically the Supreme Court stated कि if the speaker fails to follow his duty, then Supreme Court can also judicially review his decision. Okay. Now judicially review his decision. Now why this is actually a confusing part. Now see, article 212 में, यानी article 212 of the constitution ये बोलता है जो privileges की बात होती है, right. तो उसमें legislative privileges की बात होती है, parliamentary privileges. So parliamentary privileges क्या होते हैं, या उसके अंदर basically ये बोला गया है, it is part of a parliamentary privilege कि जो भी पार्लियामेंट में जो भी चीजें होंगी, राइट, on the floor of the house, जो भी चीजें parliamentary and the not in case this is the parliamentary state legislative assembly. So state legislative assembly में जो भी speaker जैसे करेगा, या whatever decision the speaker is taking or the deputy speaker or whatever is going on in the parliament is not subject to judicial scrutiny. ठीक है. यानी कि court cannot interfere. The court cannot interfere, right. But इस केस में बोला है कि in case the speaker, सुप्रीम कोर्ट ने बोला है कि अगर स्पीकर अपनी ड्यू डिलिजेंस फॉलो नहीं कर रहा, अपनी ड्यूटी को फॉलो नहीं कर रहा, in that case they will judicially review his decision. And how, why can वो judicial review क्यों कर सकता है सुप्रीम कोर्ट? because judicial review is part of the basic structure of the constitution under the basic structure doctrine. ठीक है, it is part of the part of basic structure of the constitution as the basic structure doctrine enshrined in the Keshavananda Bharati case. ठीक है, केशवानंदा भारती केस. सो इसलिए ये सुप्रीम कोर्ट, दिस वाज अनदर थिंग दैट वाज ऑब्जर्व्ड बाय सुप्रीम कोर्ट. दूसरी चीज सुप्रीम कोर्ट ने ये भी बोली कि another thing was that the speaker is also bound to give his decision in a time bound manner. टाइम बाउंड मैनर, ठीक है, यानी कि इन अ रीजनेबल टाइम पीरियड. और कुछ प्रीवियस जजमेंट्स हैं सुप्रीम कोर्ट में जिसमें कि ये जो रीजनेबल टाइम पीरियड है इट हैज बीन डिसाइडेड एज 3 months. ठीक है, तो जो स्पीकर है उसके पास 3 महीने का टाइम होगा टू डिसाइड हु विल बी द चीफ विप, हु विल बी अपॉइंटेड फाइनली एज द चीफ विप. ऑलराइट, अब अगर ये 3 month को एक्सीड करता है, द स्पीकर एक्सीड्स the time period of 3 months and has not delivered any decision in the time bound manner or in a reasonable time period, in that case Supreme Court will exercise its power, its extraordinary power under Article 142 of the Constitution of India to deliver complete justice. ठीक है, ये बोला गया है सुप्रीम कोर्ट के द्वारा, राइट. सो सुप्रीम कोर्ट, in case the speaker fails to decide or give his decision in a reasonable time period, that is 3 months in this case, then Supreme Court can exercise its extraordinary power bestowed upon the Supreme Court by the Constitution of India under Article 142 of the Constitution, right. And then Supreme Court can itself give the decision who will be the chief whip, right. Ideally the speaker, this is the duty of the speaker, this is the role of the speaker to decide who is appointed as the chief whip or not, right, who will remain as the chief whip. So ऐसे issues में ideally speaker decision लेता है, but अगर speaker अपना decision सही तरीके से क्या सही time में नहीं ले रहा है, तो उस केस में Supreme Court has the power to take appropriate actions. ठीक है, this is what it was said. और दूसरी चीज, एक और जो चीज सुप्रीम कोर्ट ने बोली, सुप्रीम कोर्ट ऑल्सो स्टेटेड दैट द गवर्नर, ठीक है, जो गवर्नर ने वो जो उनको गवर्नर को जो लेटर मिला था फ्रॉम द 16 MLAs, वो लेटर जो मिला था रेजिंग लॉट ऑफ डिससैटिस्फैक्शन अगेंस्ट द गवर्नमेंट, ठीक है, कि उनके बहुत सारे प्रॉब्लम्स हो गए थे उनके साथ बिटवीन द, बिकॉज प्रॉब्लम्स क्यों हो गई थी, बिकॉज आइडियली जो बेसिकली उनका द होल द होल शिवसेना, उनका जो आइडियोलॉजी है वो बहुत डिफरेंट है फ्रॉम द आइडियोलॉजी ऑफ द एनसीपी एंड द कांग्रेस, राइट. बट people of opposite or the parties of opposite ideologies basically formed a post poll alliance, जिसकी वजह से तो जो शिव सेना पार्टी थी उसी में स्प्लिट आ गया, राइट. स्प्लिट इन द सेंस बेसिकली उसी में बहुत सारे लोग थे which rebelled because of difference of ideologies, right. So in this case the governor, when he received the letter, so he जो उसने letter जो receive हुआ था, and he deemed the letter as a loss of confidence. तो ये सुप्रीम कोर्ट ने बोला कि this is actually wrong, this is invalid. So Supreme Court stated that this is invalid, this is constitutionally invalid. right? In this case here also, when you say, see this article, this news item, it says governors cannot play a role in intra-party disputes. So governors cannot really solve intra-party disputes. गवर्नर का काम इंट्रा पार्टी, अगर पार्टी के बीच में कोई डिस्प्यूट हो रहा है उसको सॉल्व करना नहीं है, ठीक है। और इस लेटर के बेसिस पे उन्होंने फिर फ्लोर टेस्ट अनाउंस कर दिया था, ठीक है। फ्लोर टेस्ट अनाउंस कर दिया था, दैट वाज आल्सो इनवैलिड, दिस वाज आल्सो इनवैलिड, ठीक है। बट जो गवर्नर ने एकनाथ शिंदे को अपॉइंट किया था एज चीफ मिनिस्टर, this is constitutionally valid, this is constitutionally valid, and Eknath Shinde is the legitimate person or to be holding the post of CM. Why was this valid? इसको validity क्यों मिली? Because Uddhav Thackeray had already, right, already voluntarily resigned from CM's post. ठीक है, before it was, he gave his resignation before the floor test happened, ठीक है। तो फ्लोर टेस्ट को सुप्रीम कोर्ट ने क्या किया, वो जो लेटर, जो लॉस ऑफ कॉन्फिडेंस था और जो फ्लोर टेस्ट जो गवर्नर ने कॉल किया था, गवर्नर कॉल्ड फॉर दिस फ्लोर टेस्ट, तो उसको तो क्वॉश कर दिया, राइट। Supreme Court said we can quash this floor test that was announced by the governor, even though this floor test did not take place. But the Supreme Court said that we cannot quash a voluntary resignation or a resignation that has been voluntarily issued, ठीक है। तो सुप्रीम कोर्ट किसी का रेजिग्नेशन क्वॉश नहीं कर सकती है, रेजिग्नेशन, ठीक है। So because Uddhav Thackeray had resigned, then Eknath Shinde was appointed as chief minister. Supreme Court stated that this was constitutionally valid, right? अब नाउ डिबेट, अब जो डिबेट और जो डिस्कशन चल रहा है, या सुप्रीम कोर्ट के पास अभी, सुप्रीम कोर्ट विल बी डिसाइडिंग बेसिकली ऑन दिस पर्टिकुलर इशू आल्सो एज टू हु कैन अपॉइंट, who can really appoint the chief whip. Political party or political party, or the organization, or the legislative this thing. Okay, who can appoint the chief whip? So this is also under consideration, right? Okay, so this is the whole judgment. Also एक और चीज होती है, in case a proceeding or petition for disqualification has been moved against certain MLAs, still they can participate in voting. और जो भी bill होगा, whatever is the bill is passed, then it will not be quashed or it will not be held invalid solely on the ground that it was the MLAs जिनके खिलाफ disqualification petition already is there pending, so because they voted, so it will not be held constitutionally valid. Such bill will be held valid only, right? So abhi ye jo this article, this one, see, all eyes on Speaker Narvekar for a decision on disqualification petitions. ठीक है, Supreme Court said that the speaker must decide on the petition disqualification petitions within a reasonable period. तो ये सारी चीजें reasonable period में the speaker will have to decide, right? So these are the major facts of the case and certain issues and certain concepts relevant for you to understand. All right, so I hope the facts and the issues as well as the concepts are clear. If you have any doubts related to any of the facts or issues, you can write in the comment section below and I'll get back to it. Right, and I'll take it up then. Okay, then we'll go on to the next. Okay, so we'll go on to the next issue for today. We even discussed this yesterday about the Delhi Chief Minister versus LG. That is, now अभी क्या हो गया है? The Delhi government, Supreme Court has stated, जो हमने कल discuss किया था, whether the Delhi government has control of the officers or over the administrative services, that is the bureaucracy or not. So the Supreme Court has stated that the Delhi government has control over the officers, right? In a blow to the center, the Supreme Court on Thursday gave the Delhi government power to make laws and wield control over bureaucrats deputed to its departments while declaring civil service officers are politically neutral professionals who serve the people, not the party. So the civil services officer, it is stated by the Supreme Court that they are politically neutral professionals and they serve people and not the parties. So, a constitutionally entrenched democratically elected government needs to have control over its administration. मतलब इसमें सुप्रीम कोर्ट कह रहा है कि जो भी democratically elected government है, right? The government which is constitutionally entrenched and democratically elected needs to have control over its administration. अगर लोगों ने जनता ने अगर वोट करके आम आदमी पार्टी को जिताया है, whoever is the government who is in power, then that government should have the control over its administration. The administration comprises of several public officers who are posted in services of a particular government, irrespective of whether or not the government was involved in their recruitment. Right? This was stated by Chief Justice of India, Justice D.Y. Chandrachud. Right? And it debunked the center's argument. So the constitutional bench headed by CJI also reiterated that the National Capital Territory of Delhi would not have the power to legislate on public order, police and land. Right? And the legislative, मतलब जो पहले की जो powers थी, they will remain same, but the services will actually come under the party that is or the elected government. ठीक है, elected government, because this is a representative democracy, right? Here again you can see the Supreme Court on Thursday dismissed the centre's claim for superiority over the elected government of Delhi on the ground that the national capital is the seat of the union government and national interests takes precedence over and beyond the quibbles of local interests. The centre backed its argument insofar as such matter is applicable to the Union territories, Article 239 AA 3A of the Constitution. The article introduced through Constitution Amendment Act 1991 declared National Capital Territory a special status on the NCT of Delhi, National Capital Territory of Delhi, which we discussed yesterday, right? The Legislative Assembly of Delhi shall have power to make laws for whole or any part of the NCT with respect to any of the matters enumerated in the state list or in the concurrent list insofar as such matter is applicable to union territories. Right? Under this article, you can see the LG does not have sweeping executive powers. So Supreme Court has laid down that the Lieutenant Governor does not have sweeping executive powers. Delhi is a unique. So Supreme Court also stated that Delhi is unique and it follows an asymmetrical federal model of governance. Asymmetrical federal model means that there is a distribution of power. So the distribution of power is there. Distribution of power between center and state, in this case Delhi, right, is asymmetric, right? It is asymmetric. The center should remain within its boundaries, says Constitution Bench. All right, we even talked about the Amendment Act, the 2021 Amendment Act, and there were several cases that we discussed yesterday. So we'll just quickly brush up through those case laws. Okay, see. So Delhi is accorded special status under Article 239 AA of the Constitution. This was introduced, or this was inserted in the Constitution by the 69th Constitutional Amendment Act of 1991. Okay. This confers special status on Delhi, on the National Capital Territory of Delhi, NCT of Delhi, right? And this was followed by S. Balakrishnan Committee. Some of these facts can be important from the point of view of your legal GK as well as your general GK point of view. Static legal as well as GK, right? So the NCT, it was stated in that the NCT of Delhi will have an administrator and a legislative assembly, right? So administrator, that is the Lieutenant Governor, and the legislative assembly. The legislative assembly shall have the power to make laws for whole or any part of NCT with respect to matters enumerated in the state list, except on the subjects of police, public order, and land. Okay. On these subject matters, central government will make the laws, right? And the status of Delhi being a union territory under Schedule 1 of the Constitution. So it was given the name of National Capital Territory. Okay. And the administrator, basically it was stated that LG, who is the administrator, works on the aid and advice of the Council of Ministers, ठीक है. तो जो एड एंड एडवाइस का इशू है उससे लेके बहुत सारे जजमेंट्स हैं, राइट? सो क्या क्या जजमेंट्स हैं इन केस आर्टिकल 239 AA है, इट आल्सो एम्पावर्स the Lieutenant General to refer a difference of opinion on any matter with the Council of Ministers to the President. So LG क्या कर सकता है अंडर आर्टिकल 239A, अगर कोई डिफरेंस ऑफ ओपिनियन है, difference of opinion between the LG and the Council of Ministers. If there is a difference of opinion on any matter, right, and not just public order and police and land, ठीक है, any matter पे difference of opinion है, then LG can refer that to President, ठीक है. Um, okay, this is the dual control between lieutenant governor and the elected government, and this dual control basically leads to power tussle. अभी ये जो problem चल रही थी, this was the hearing that was going on was with respect to control of administrative services, control of administrative services, for which the Supreme Court has already stated that the civil service officers are politically neutral professionals who serve the people and not the parties. So, if and the whichever government is constitutionally elected and democratically and constitutionally elected, that government should have the control over the administrative services. Okay. So, basically, this is what the news items deal with. This is the issue, right? All right, so now this is all for today. Let me know if you have any doubts or any questions regarding the two issues that we discussed today. You can write it in the comment section below, and then I'll get back to it. And you can also join my Telegram channel for regular updates. Okay, all right. So